Morning, everyone. Welcome to episode 1 of the Healthcare Podcast. Let me introduce myself. I'm Hui Li. We are glad to have here today our friends of various professional backgrounds.
Hi, I am Lorena. Good morning, I am Zahira.
Hi, I'm Silva.
You may have heard that vicarious liability and non-delegable duties have become increasingly intertwined and evolving in recent years, particularly in the healthcare sector. Before we discuss on the non-delegable duty of care, we must first understand what is vicarious liability. The doctrine of vicarious liability holds employers liable for torts committed by their employees while acting in the course of employment. In other words, the hospital as the employer can be held vicariously liable for their employees' negligence if the negligence act occurred in the course of employment. In Malaysia, there are several legislation governing the relationship between an employer and employee. You have the Employment Act 1955, the Industrial Relations Act 1967, and the Occupational Safety and Health Act 1994, and many more. In public sector, subject to Section 5 of the Government Proceeding Act 1956, it provides the government's vicarious liability in tort in which the government of Malaysia is liable for the negligence of its servant. It extends to the director of the hospital, being the principal of the hospital, may be held liable for the negligence act done by their staff, for example, the doctors and nurses who enter into the contract of service are categorized as employees acting in the course of employment. However, in the Malaysian private healthcare facilities, doctors are typically enter into independent contractor agreements with hospital whereby the doctors run their medical services on their own in collaboration with hospital that provide the premises, equipment, and staff. As mentioned by Lord Bridge in DNF Estate 1989, the employer of an independent contractor is not liable for the negligence or others tort committed by the contractor in the course of the execution of the work. Thus, traditionally, private hospital can avoid liability toward independent contractors because they were viewed as separate entities from the private hospital, both economically and legally. With the recent decided cases, the Malaysian Apex Court has shed judicial light and held that the doctrine of non-delegable duty of care may be imposed on private healthcare facility in circumstances where the requisite features are met. So, what is non-delegable duty of care? The duty is said to be non-delegable because it cannot be discharged merely by delegating the task to a competent person. In principle, an employer may not be vicarious liable for loss or injury caused by an independent contractor. However, with the imposition of non-delegable duty of care, the private hospital duty cannot be discharged simply by delegating the task to the competent consultant, and the hospital may still be liable if the task is not properly performed. Furthermore, the court will evaluate and determine a doctor who contracted the tort as an employee or an independent contractor by looking at their employment status, the method of salary payment, the control and power of the employer has over the employee, and if the doctor is found to be an independent contractor, the hospital's liability is not vicarious, but the hospital may be liable for non-delegable duty of care if the defining features are met. The principle of non-delegable duty is expounded in Cassidy and Ministry of Health and a case of Go and Essex Country Council.
The doctrine of non-delegable duty of care and the defining features were also articulated in the case of Woodland. Zarina, will you please share the case with us?
Thank you, Pui. So the UK case of Woodland and Swimming Teachers Association is a case concerning negligence and duty of care. To summarize the facts of the case, the claimant was found hanging vertically in the water during a swimming lesson, which resulted in her suffering serious brain damage. This made her bring an action against the swimming teacher and the lifeguard for the damage she suffered. But both the teacher and the lifeguard were independent contractors, which were employees of a third party. The issue of this specific case was whether the defendant owed a non-delegable duty of care to the claimant. So the Supreme Court allowed the appeal, and it was held that the defendant owed a non-delegable duty of care to the claimant. The outcome of this case has resulted in Lord Sumption concluding that there are two broad categories under this case. The first category is such that the defendant had engaged with a contractor to perform a high-risk activity, and Lord Sumption added that a swimming lesson was not a risky activity. The other broad category consisted of three critical characteristics. The first one arises from the antecedent relationship between the defendant and the claimant, not from the negligent act. For this, to go into detail, an example of an antecedent relationship between the claimant and the defendant can be observed as when a patient relies on the hospital system to appoint a doctor that can attend to the patient's needs. The second characteristic is that it is an affirmative duty to protect a particular group of people against a set of risks. And the third category is that the duty remains with the defendant, even if the work is delegable by nature. Furthermore, Lord Sumption laid out a framework to determine the existence of a non-delegable duty of care. This framework consists of 5 defining features. 1. The claimant is vulnerable and dependent on the defendant's protection from the risk of injury. 2. There is an antecedent relationship between the claimant and the defendant, which leads to the assumption of responsibility on the defendant to protect the claimant from harm. 3. The claimant has no control over the defendant's style of performing the obligations, either personally or through employees or even through third parties. 4. The defendant has assigned a function that is fundamental to the positive duty to the third party, along with the custody and control that is incidental to said function. And lastly, 5. The third party was negligent in his performance of the same function that was assigned to him. A person is said to owe a non-delegable duty towards the other when the 5 criteria laid out under the Woodland case are satisfied, and thus building a guideline to establish the existence of a non-delegable duty outside of the risky activity category. According to the case of Gold and Essex County Council, the enforcement of non-delegable duty is important so the defendant takes care of his own liability. This enforcement would also protect the safety of the claimant that is vulnerable and dependent on the defendant's obligation. Basically, that is the Woodland case in a nutshell. Yunhua, are there any other notable cases in Malaysia?
Okay, thank you, Zarina, for the comprehensive overview of the Woodland test. So I would like to share a Malaysian case which also using this test. So the case that I want to share is the case of Dr. Kok Chun Sing and Su Chen Ling. So the plaintiff actually had a lump in his left forearm and then have consulted Dr. Kok as his private clinic in Taman Desa. So Dr. Kok advised the plaintiff to go for the surgery to remove the lump. So with the plaintiff consent, so Dr. Kok actually wrote to the Sunway Medical Center for the plaintiff to be admitted there for the operations. Patients was operated the next day. So after the surgery, there are few occasions that the plaintiff actually complained to Dr. Kok that there are pain and numbness at the area of the forearm which was operated upon. So the plaintiff was subsequently referred by Dr. Kok to Dr. Ranjit Singh, who is a hand and microsurgeon from Pantai Medical Center. So the plaintiff was subsequently diagnosed to have a median nerve injury and needed further surgery. So because of this, the plaintiff actually brought an action against the Dr. Gok and the hospital for negligence and breach of contract. It was alleged that because as a result of the Dr. Gok negligence, the plaintiff actually suffered injury, including the pain, numbness, and weakness in his left arm. The plaintiff also alleged that the hospital actually owed him a non-delegable duty to ensure that he was actually treated with care and skill by the healthcare personnel at the hospital. And also, the hospital actually failed to provide a safe, reliable system for the treatment and referral of patients. The High Court judge actually found Dr. Gok liable in negligence in his capacity as a medical practitioner. And the hospital is liable in negligence as a provider of the healthcare services, which include the competence, skill, and expertise of Dr. Gok. The judge also held that the hospital actually owed a non-delegable duty of care to the plaintiff. The Court of Appeal dismissed the hospital appeal on the liability, but in federal court, the judge held that the hospital is actually not liable for the breach of non-delegable duty to the plaintiff, as the defining features of the non-delegable duty identified in the Woodland actually are not present in this case, especially the second one. The argument was, all this while plaintiff has been seen by Dr. Gok as his private clinic, and Dr. Gok is the one who arranged his admission to the Sunway Medical Center for the operations. Therefore, it is reasonable for the plaintiff to expect the operation to be conducted by Dr. Gok with dual care, but the role of hospital here just merely to provide the relevant facility required for the plaintiff's operations. In respect of the conduct of the surgery by Dr. Gok, the judge do not find that the hospital actually has a positive duty to protect the plaintiff from surgery. Since the Sunway Medical Center do not have a duty to provide the medical service to the plaintiff to begin with, therefore, it was contended that the questions on non-delegable duty actually does not arise as the Woodland test was not satisfied in this case. Having said that, if I give you another hypothetical situation whereby the plaintiffs go to the hospital first and then rely upon the hospital internal system to be referred to any suitable doctor on duty. So in that situations, the doctor having accepted the patients and undertaken to treat him, the hospital may well be under a non-delegable duty to ensure that he is treated with dual care by whomever the hospital delegate the duty to. That's all for my sharing of the Malaysian case. Takira, do you have any overseas cases to share with us?
I actually do, but let's not go too far, Tiwa. Let's look at our neighboring country, Singapore. In the case of Management Corporation Strata Title Plan number 3322, or MCST for short, and Tioke Ike Construction, the Singaporean Court of Appeal noted that hospitals and health authorities have been observed to owe non-delegable duties to their patients. Without a doubt, this case makes it very clear that Singapore follows the UK Supreme Court's framework in Woodland, of course with considerations made on public policy and on the ground of fairness. It was held that the argument of non-delegable duty did not stand as the second defining feature set out in Woodland was not present. MCST was not in the custody, care, and charge of the respondents. The respondents also never exercised any control over MCST. MCST was never vulnerable or dependent on the protection of the respondents, and the transaction was completely commercial. The contract entered between the developer and the respondents clearly contemplated that respondents would engage in subcontractors. In the Singaporean case of Hai Chi Kok and Oi Peng Jin London Lesion, the High Court rejected that the National Cancer Centre of Singapore has a non-delegable duty of the doctor that performed the surgery, as the National Cancer Centre of Singapore was only a specialist medical clinic. Surgery did not fall under its functions. Therefore, there was nothing for the National Cancer Centre of Singapore to delegate to the Singapore General Hospital anyway, despite their recommendation or assistance for the surgery to be performed at Singapore General Hospital by that doctor. Upon appeal, as the Court of Appeal found that there was no negligence. The question of whether the National Cancer Centre of Singapore owed the patient a non-delegable duty was neither affirmed or rejected. In Ng Huan Seng and Munib Muhammad Madni, the Singaporean Court of Appeal reiterated MCSD, setting out the test where a non-delegable duty could arise. 1. Either it fell within an established category of non-delegable duties, or second, the facts of the case contained 5 defining features of the Woodland case, which Zarina had previously discussed about. Additionally, the court will also have to consider the fairness of imposing a non-delegable duty, as well as relevant Singaporean policy considerations. The Court of Appeal made a comment regarding hospitals and patients, saying that when the established categories of non-delegable duties are examined, such dependence or vulnerability arises by virtue of the defendant undertaking or assuming some form of responsibility to the claimant. In keeping with this, non-delegable duties have typically been found in the context of custodial relationships, for instance, hospitals with regard to patients under their care. The High Court of Singapore applied Lord Sumption's non-delegable duty framework in the case of D&M and National University of Singapore, where the employer was sued in tort by the estate of a deceased employee who drowned while swimming at one of the company's pools. Inter alia, the question that the court had to answer was whether the employer could delegate the responsibility for hiring qualified lifeguards. Since the majority of the defining features in the Woodland case were missing, the responsibility was delegable. Do you agree to impose non-delegable private healthcare facilities?
Yes, I do agree to impose non-delegable duty of care in private healthcare facilities. This is important so that the private healthcare facilities will ensure the patient safety by monitoring the doctor's practice within the hospital facility. Furthermore, regardless of the business arrangement between the doctor and the hospital actually owes a duty of care to its patients. Patient only knows that the treating doctor is appointed by the hospital administration, and the hospital should be held accountable for the doctors who work in their facility. Besides, the imposition of a non-delegable duty of care on private healthcare facilities is especially significant where there is no vicarious liability. For example, ventilator failure and no individual tortfeasor can be identified during the patient's hospital stay. And furthermore, this can ensure that the private healthcare facility will ensure that all their facilities are on good terms and in providing the hospital services. Yes, Suba, I'd like to hear your thoughts on imposing non-delegable duty of care on private healthcare facilities.
Okay, thank you, Preely. So actually, after much discussion, at present time, we can never say that all private hospitals are always or never under a non-delegable duty to the patients. I think because role of the hospital sometimes can be vary from patient to patient, then the extent and the scope of the hospital duty towards the patient sometimes must be ascertained from the facts and the circumstances of the cases itself. Then whether the private hospital are in the breach of the non-delegable duty by reasons of the negligence of their doctors practicing, I don't think it can also be predetermined by a general pronouncement. The non-delegable duty sometimes impose more onerous obligations. Therefore, I think it should be imputed only if it is fair, just, and reasonable. Yeah, but however, I think the guiding principle we find in the Woodlands can be quite a smooth starting point. That's all my sharing.
So that's all the time we have for today. Thank you so much for tuning in this episode of Non-Delegable Duty on Private Healthcare Facilities. Thank you.
Bye.